Asbestos in Australia is a story of tragedy. It was once considered a superb building material. Light, strong, fireproof. Asbestos fibreboard, fibro, was everywhere, and the biggest supplier of asbestos products was James Hardie Industries. Eventually, we learned that exposure to asbestos particles in the air, even the briefest exposure, could cause lung diseases, often untreatable and terminal. There are so many victims that New South Wales has a dedicated tribunal for them. Much of the liability, inevitably, fell on James Hardie Industries. To save the company, the board of James Hardie came up with a plan to establish a medical research and compensation foundation, fund it with nearly $300 million in assets, and then to have that foundation as the defendant for compensation actions. Was $300 million enough? The board sought expert advice, and the expert advice was unclear. There was no clear advice that $300 million would be sufficient money. This didn't stop the board from approving and releasing a press release and market announcement describing the foundation as fully funded. The Australian Securities and Investments Commission, ASIC, alleged that this statement was false and misleading and a breach of directors' duties. Justice Zell therefore had to consider the nature of those directors' duties and whether they had been breached. He said, "In determining whether a director has exercised reasonable care and diligence, the circumstances of the particular corporation concerned are relevant, the type of company, the provisions of its constitution, the size and nature of the company's business, the composition of the board, the director's position and responsibilities within the company, the particular function the director is performing, the experience or skills of the particular director, the terms on which he or she has undertaken to act as a director, the manner in which responsibility for the business of the company is distributed between its directors and its employees, and the circumstances of the specific case." He went on, "In determining whether a director has exercised reasonable care and diligence, one must ask what an ordinary person, with the knowledge and experience of the defendant, might be expected to have done in the circumstances. The non-executive directors of James Hardie must have been aware that the draft ASX announcement conveyed a reasonable basis for the assertion of certainty of sufficient funding. As a result, the non-executive directors were held to have failed in their duties."